Now in open session pursuant to adjournment.
Good morning, ladies and gentlemen. Our first case is 2020-676 and 2020-683. James D. O'Neill and Cleveland Jackson versus the state of Ohio et al. James Derek O'Neill et al. Versus the state of Ohio et al. For the appellant, we have Ms. Shank.
Good morning, Chief Justice O'Connor and your honors. I would like to reserve 8 minutes of my time for rebuttal. May it please the court. Ohio's death penalty is carried out under the methods, processes, and procedures set out in 01 Com 11, a rule that was adopted by the Ohio Department of Rehabilitation and Correction without complying with the rulemaking requirements of Ohio Revised Code Section 111.15. Appellants O'Neill and Jackson are both sentenced to death in Ohio and have execution dates. O'Neill on August 16th, 2023, and Jackson is set for June 15th, 2023. Thus, they are soon to be subjected to 01 Com 11's methods, processes, and procedures. Rules subject to 111.15 are invalid if the statutory rulemaking requirements are not followed. And they were not in this case.
Counsel, what's your argument that this is a day-to-day occurrence?
Your Honor, it has not been a day-to-day occurrence so far, but it could be a day-to-day occurrence. It all depends upon the timing and scheduling of execution dates. For example, in Texas, executions are very frequent. Sometimes they'll have 2 or 3 in a week, but at this point, it only has the potential.
We're not in Texas. And we've been averaging 2 or 3 a year for the last 20 years.
That is true, Your Honor. But even if it's not, and I think you're referencing an internal management rule, even if it's not an internal management rule, it is a rule under the definitions of 111.15. 111.15 says that defines a rule as any standard having a general and uniform operation adopted by an agency under the authority of the laws governing the agency. 01 Com 11 meets that definition. First, it has general and uniform application. It applies to every death sentenced prisoner executed in Ohio. The appellant or appellees admit this. Director Moore testified to it, and there's nothing to contradict that. Second, it was adopted under the authority of the laws governing the Ohio Department of Rehabilitation and Correction. Specifically, that's 5120.01. 01 Com 11 says on its face that it was adopted pursuant to 5120.01, and Director Moore testified that it was. In addition, 5120.01 requires that the department, when it's carrying out duties conferred by law, perform under rules and regulations prescribed by the director. The duty to carry out executions was entrusted to the department under 2949.22a.
Okay.
So, yes.
What is the substantive difference between a rule and a regulation?
Well, under the definition, a rule and a regulation basically are the same thing. The full definition of a rule includes rules, regulations, bylaws, and standards. I'm not sure is that what you were looking for, Your Honor?
Precisely. Thank you.
Okay. One of the things that I guess I could tell you is that—
Counsel, before you go any further, that same section that you just referred to as rule, it does have the last sentence. It says a rule does not include, and it says any order respecting the duties of employees. And the protocol that is in question here, it does govern the duties of employees that are designated with this responsibility, is it not?
Well, certainly there are some aspects of the protocol that address matters that could be considered to be duties of employees.
And what are
But
those?
Well, for example, it sets out the timing of escorting witnesses to the death house. It sets timing requirements for employee training. It sets parameters for who may attend the execution. So it's a sweeping.
Doesn't it even go further though, to what happens with the inmate as far as what they eat, and the timing of that, last meal, all that sort of thing leading up to the transport or walk to the death chamber?
It does include all of those things, but what it does that's important here, because the duty entrusted to the department under the law 294922 is carrying out the execution. And in this instance, the execution is defined by the statute 294922 as an injection applied to the inmate of a drug or combination of drugs that will result in a quick and painless death. And those aspects of the protocol are where we see significant change in the characterization of the duties. For example, no injection is given to the inmate under the current protocol. And as a result of that, without this protocol, the execution process that exists today and that is used on Ohio's executed inmates cannot be found in the language of the rule. So it's possible that it could be severed into some things that fit the kind of duties that do not have to be enacted by rule, but the duties that describe the execution process are entrusted to the department by law, and therefore under 512001 must be enacted by rule.
And I guess it goes without saying that everything that's enacted has to be carried out by staff. It's individual duties here.
Well, yes.
In other words, the rule does not include any order respecting the duties of employees. Seems to me that, Revised Code 11 or 111.15 is a little contradictory in A1. Everything that has to do with the operation has to be done through the duties of the employees.
Well, Your Honor, and that is why I assume the legislature said that duties entrusted to the department must be carried out under rules adopted by the director. Because those duties, carrying out executions, there could hardly be anything that is more substantial in terms of the impact on a human being than having an execution carried out. It makes sense that a department that incarcerates and punishes is a department that the legislature said in 512001 must enact rules to carry out duties entrusted to it by law. And there is no dispute as far that it was entrusted by law. It's on the face of the protocol, and it is the director's testimony. So,
from just a policy standpoint, you're looking for this to be codified into the Ohio Administrative Code for transparency, correct?
I apologize, Your Honor, I could not hear your question.
Okay, so for the sake of, I don't think I'm muted, no. For the sake of just the motivation to pursue this action, it's because of transparency, correct?
Transparency is an important part of it. In fact, I think that transparency is a significant issue. During his deposition, Director Moore testified that the difference between a policy and a rule is that a policy can be promulgated under the authority of the director as ultimately through 512001, and an administrative rule has a set of requirements that ultimately ends up in front of a legislative committee with a public hearing. That is the difference. So a significant aspect of the difference recognized by the ODRC when they failed to comply was that they didn't have to go to a legislative committee, and they didn't have to go to a public hearing.
But let's presume that the director of the ODRC and the employees who carry out this very grave task are giving it their all, and they're trying to do everything right, and they're trying to do this in a way that is quick and painless. I think that the rule does not include orders respecting the duties of employees. Things can happen as they have in the past, and things can change. Perhaps a drug provider won't give the department that drug anymore, or perhaps they find that if we just did this a little bit differently this way in our established protocol, it would actually make things more humane for the prisoner. And so should the department have to be bound by the onerous process of rulemaking, which requires days and weeks and months and public hearings, and frankly, a lot of opinions from JCAR, when oftentimes with them being right there working with the prisoners, they may need the ability to pivot quickly to do it in a caring way.
Well, first, Your Honor, there really is no execution that the specific date that it's set for, at least as far as I am aware, is critically needed to be done on that particular day. Our system is designed to allow opportunities for more time with issues with court processes, with issues with power outages. There's nothing that says it has to happen that day. If something comes up and there is a need to make a change, no one is harmed by taking the time that justice requires to make the change in conformity with the law. And the law is 111.15 and carrying out the rulemaking authority there. Plus, remember, 5120.01 places a special and specific duty on ODRC to carry out the duties imposed by law on that department by rule. So letting it slide, saying it needs a quick action, saying that we don't need to comply with those laws does not actually benefit anyone.
Well, I'm only thinking about instances in the past. I'm looking back in 2009 when the prisoner is on the table and things aren't working right, and and they tried for a long period of time, and I think it's kind of immeasurable what that does to the prisoner, what that does to the prisoner's family, and more so even to the victim's family. I guess I'm just having a hard time. I wanted you to talk about some of these because all these other things are technical and we can look at all these issues, but I really wanted to see what the motivation was here to pursue this as we look at the technical arguments.
Well, first of all, I think one of the primary motivations here is, and this is a declaratory judgment action, we're just finding out what the actual parameters of the law are. Is critically important. I mean, knowing on the day that a person is facing execution that the law has been complied with and that what they're facing has been reviewed and tested and understood by the legislature, public comment, and upheld by a court simply is important. To go to an execution date as a prisoner and feel that the process that's being used to carry out your death is not the process that the Ohio General Assembly said was supposed to be used makes that something other than a legitimate punishment. Understanding and clarity about the source of the law and the application of the law is critically important. So that alone is a very important aspect of this litigation. And finding that out, knowing that answer will be redress for both O'Neill and Jackson.
Counsel, the protocol for executions in Ohio has been stayed by the federal courts at times, correct?
At times.
And now unless my understanding is not up to date, the federal court has signed off, so to speak, on the current protocol. Is that correct?
Well, Your Honor, it's still under litigation. There have been some executions that have been allowed to proceed under this protocol, but the questions about the protocol continue, the litigation continues. So I cannot say that there's a final order out of the court on the legitimacy of the protocol.
Okay, but the last, what we understand last from the federal court is they allow this protocol to be utilized to execute prisoners.
That's true. But
Okay.
I will point out, Your Honor.
Wait a minute, let me ask the question. So how does that interact with, I guess, your position that somehow the protocol is illegitimate?
Well, the federal court litigation focuses on the Eighth Amendment to the United States Constitution. There, the standard is whether or not it's cruel and unusual punishment. Ohio's General Assembly has said that the executions that will be used by this state must be quick and painless. So all of the assessments that have been done in the federal context, actually, I believe the Sixth Circuit has admitted that the process that we use has some aspects to it that are painful. So whatever the federal court has done, it's under federal law. It does not address the Ohio statute. I'm sorry, Your Honor.
But it's impossible to have an execution that doesn't have some sort of pain associated with it.
I respectfully believe that that's not true, Your Honor. I know that there are certain gases that people can inhale. I think it's something like nitrous oxide. There are many other options out there that can result in an actual painless death. I mean, the reason that I mention that is because there are OSHA rules about those who work around it. Your body thinks it's oxygen, and so you don't know anything's wrong until you are passed out. So it's not true that there is not a way to execute someone painlessly. So Ohio's standard can be met. So I'm going to go on to the Court of Appeals ruling. We've already talked a little bit about the order. And what I wanted to say to you was that the first and most significant reason that we should recognize that it's an order is the fact that Director Moore, the one who adopted it, testified extensively in depositions about it. And it was always either a protocol, a policy, or on a few occasions, he even called it a rule. He is the director who would have been issuing it as an order, were it in order, and he never said it was an order. I think the fact that it's self-executing is apparent. The law in Ohio is firm. Probasco v. Rain and State v. Tony say that once a statute's enacted, that's the law. The final thing I wanted to mention briefly, I think I'm running it up against my time. I can't, oh, there we go.
Counsel, you're over your time. So we will move on now to Mr. Hendershot.
Thank you.
Thank you, Your Honor. Chief Justice O'Connor, and may it please the court. Jackson and O'Neill face both a threshold problem and a merits problem, but I want to start off with the Chief Justice's question about the definition that includes both general and uniform, but also carves out orders to employees, and how do those fit together? And what I would direct you to is the language effective in subparagraph B1 of the statute. We think that word effective, a rule is effective if it follows the process. It's not effective if it doesn't. What that points out, and I think this is well illustrated by the cases that I'll mention in a moment, is that a rule is something that has the force of law and is necessary to authorize the executive action, whatever it is, across all the contexts. Remember, this statute doesn't just apply to the Department of Rehabilitation and Correction, but to all the executive actors of the state. So that word effective, and let's move on to the cases and see how that distinguishes this court's and other courts' cases. So you have cases like Adams and Saunders saying things that are not rules. Why is that? because those things do not need to have the force of law to authorize executive action. But contrast that.
Are you saying that if a statute requires that rules be promulgated, that until the agency promulgates those rules, they cannot take any action under that statute?
Well, I'm saying, yes, when rulemaking is required for certain kinds of action. I think this explains the internal management rule piece of this and all the parts of 111.15. Now, we think that many executive actions can take place without rulemaking, and that we think is the key problem with Jackson and O'Neill's theory, is that they look primarily at the general and uniform language and not the carve out for orders to employees. And I think it also clashes with the cases that recognize Adams and Saunders. I'll keep coming back to those as two of this court's cases that draw the line between mere implementation and interpretation and establishing a policy. And so that line, we think, is something that Jackson and O'Neill's theory butts up against. And it also, I think, connects with the question, Justice Spooner, that you asked about flexibility. So certainly if we just use the general and uniform test that Jackson and O'Neill are proposing, it eliminates flexibility, not just for the guidelines we're talking about here, but across all executive agencies. And that flexibility, as I think your discussion with Ms. Shank pointed up, if you have something sitting before JCAR, you lose the flexibility to adjust things. And that's exactly what if you look at the statute that authorizes these sentences, by not specifically pointing to either rulemaking statute and by leaving that flexibility, that's what the General Assembly was intending here, was to leave these sort of checklists and guidelines to employees. I mean, the protocol describes itself as a guideline. It talks about approximate timelines. It leaves discretion to the director to adjust things. And if you look at former Director Moore's testimony, here's just one example. He said, this is at page 65 of his deposition, that many times they did adjust things like visitation schedules and so forth, so that an inmate that requested more visitation time, they varied from the policy, not in a way they had to go and let that rule sit before JCAR for months, but instead within the 30-day window or the 7-day window or even the day of window of carrying out the sentence. Now, let me back up for a moment and mention the threshold issue, because I think it's one of two independent reasons to affirm what the 10th District did here. And that's a question about redressability. We think that Jackson and O'Neill lack standing because they lack redressability. Redressability requires that an order of the court would change something on the ground. It would redress the injury. And here, and I would point this court to its 2018 decision in the Food and Water Watch litigation, where it said in paragraph 23, the possibility that rulemaking would change something on the ground is not enough to establish redressability. You need a certainty that rulemaking would change things on the ground. And here, nothing about this protocol being either unwritten, written informally, or being a formal rule changes the power of the department, indeed the duty of the department to carry out this very grave task. And we think if you
who else would have standing then than the person being executed?
Well, sometimes there just isn't standing, Your Honor. And
right.
Sometimes standing is not something that exists in every case to litigate every disagreement you may have with the way that the government is operated.
No, I agree with you on that. But is there anybody else that would have standing?
Probably not, since these are orders to employees. I mean, I suppose maybe it's conceivable, and here I'm not just thinking about this protocol, but these internal things that really are internal management rules, maybe if they direct certain employee action, possibly they would have standing. But at the very least, to have redressability, the rulemaking has to change the outcome. So that comes straight from the Food and Water Watch. So there could well be things that are, well, let's just take some examples from the case law. So in the B&T Express case from the 10th District, or the Ohio Nursing Board case from this court, in both cases, this court said the particular action, the fine against the motor carrier in Express and the nursing license in the Ohio Nursing Board decision, this court said those needed to be rules. There was standing because that would have changed the possibility of fining the motor carrier or the scope of the LPN license in the Ohio Nursing Board case. So that both shows how you would have standing. And we think also connects with our theory, again, keying in on the word effective. It shows to be a rule, it must be something that is required, has the force of law, and is required to authorize executive action. that explains cases, again, like Adams and Saunders. Those do not need to be in place to authorize the executive action going on there. One practical point, Your Honor, beyond the flexibility issues that I mentioned before, and why even those subject to this protocol, we think would want the flexibility that former Director Moore testified to, and the kind of flexibility, I don't think this incident was in the record, but there have sometimes been adjustments to the procedure to accommodate medical issues that arise for the inmate. But another practical point is Revised Code 121.95F. It's a relatively new statute, but it requires that when new regulations are put in place, that two existing regulations are taken off the table. Well, if Jackson and O'Neill are right, that everything that is general and uniform must be something that is put in a rule, immediately that will take other rules off the table, and then someone will point to those and say, well, those were rules, those needed to be rules. You have this sort of snake eating its tail problem if the very broad definition that Jackson and O'Neill proposed goes into effect. So that just shows that looking at the revised code as a whole shows the problem with Jackson and O'Neill's theory.
Counsel, that section that you just referred to, where if you impose a rule, you've got to eliminate a rule. Am I understanding that?
Yes, that's the way we read the statute, Your Honor, that it's a 2-for-1 reduction.
All right. Does that indicate that that the establishment of rules is disfavored by the legislature?
Well, it's suggesting that maybe agencies should take a look and only put things in rules when it is necessary. It certainly is suggesting that at times to not over-designate things rules. I think that's at least one lesson. I don't want to try to get into the mind of everyone that voted on that, but I think the text of it certainly suggests agencies should take a close look, and fitting that together with the statutes that do require rulemaking, it just shows that it's not as all-encompassing as Jackson and O'Neill's theory would inevitably lead to. So we think it not only clashes with the carve out for orders to employees. When you read through this protocol, it's plainly a checklist, a series of orders about what to do approximately, it uses the word approximately many times, what to do when. And we think Jackson O'Neill's theory also clashes with the cases. It can't draw the dividing line that this court has already drawn between, use the words in Saunders and the Ohio Nursing Board decision, drawing the line between implementation and establishing a new policy. Nothing about this protocol establishes something in the way that the scope of the nursing license was established, in the way that the fines against the motor carrier were established in the nursing board and the B&T Express cases, respectively.
Mr. Hendershot, when you're saying you have to, if you impose a rule, you have to eliminate a rule, you're talking about amendments. You're not talking about new rules, correct?
Your Honor, I think that statute applies to new rules. I mean, many of them may fall in B amendments, so I guess it depends on how you interpret that statute. But even if you put that aside, I think the language, just cabining ourselves to 111.15 and taking account of the language saying that orders to employees are exempted, and then using that to draw the line this court has drawn between implementing and establishing, that we think plainly shows that this policy, this protocol, falls on the orders to employee side. And that leaves the kind of flexibility that simply makes sense in this context, where those doing their best to carry out the gravest thing that our government does have the flexibility to do so. And one other thing related to flexibility is transparency. It's true that in some cases, making something a rule increases transparency, but this protocol has been transparent for decades, frankly. It's been on the internet. You can find it from anywhere in the world. There's nothing being hidden here, in contrast to some other states that certainly don't publish everything about the details. And if you read through the protocol here, I mean, everything is laid out in some significant detail.
Counsel, if a rule was established, I mean, if we said you have to have a rule, and then presumably the contents of this procedure as is in place now would just be transformed into a rule. Is that fair to say?
I guess that's what I take Jackson and O'Neill's request to be, is that something exactly like what the protocol looks like goes through the formal process and then becomes
all right. In the formal process of establishing a rule, is there debate and discretion by the authority approving the rule
Well, I mean, certainly, as Director Moore testified, there was a lot of debate and discussion to establish this protocol. What would happen?
Well, I
it would
understand
depend
that.
on.
I understand that. That's a different arena. When you establish, a rule is submitted, what is the oversight and who gives it the stamp of approval?
Yeah, that depends on whether it's an internal management rule or not under this particular statute. So dividing off the 119 rules, which are even more formalized with public comment. Here, if it's an internal management rule, it simply has to be filed. If it's the everything else category, it's something that it goes before JCAR for their comment. And my understanding in practice is that that almost never results in, it's up to JCAR, as I understand it, to have any kind of hearing, and almost never happens. There is a lot of rulemaking, although maybe there'll be less with this new statute. But it is the vast majority of the debate about this, as former Director Moore mentioned, was on the inside DRC and talking to all the stakeholders that are involved in it in that instance.
So the debate over whether or not the death penalty, we should have the death penalty, or the death penalty is constitutional or whatever, that takes place and will continue to take place in the courts. And
Of course,
this is what seems to me as a request for an administrative action.
Yes, Your Honor, although we recognize it deals with a very grave subject, the actual particulars that are in the protocol have been the subject of ongoing and continuous federal court litigation as long as I've been with the office, and I think it predates me by quite some time as well. So those have been tested repeatedly before the Federal District Court in the Sixth Circuit, including the Sixth Circuit en banc a couple of years ago. Your Honors, at bottom, we think there are two independent issues here, a standing issue, and I'll direct you to paragraph 23 of Food and Water Watch on that, and a merits issue, especially looking at the word effective, and a theory that we have offered you, I think, draws the line that this court's cases do, whereas Jackson and O'Neill's theory would really encompass almost everything out there because they focus on the general and uniform language. For either of those reasons or those that we've offered you in our briefing, we ask you to affirm the judgment of the 10th District. Thank you.
Thank you. Ms. Shank, you've used all your time. You may take a minute. You have to unmute yourself.
Your Honor, I think that the question of agencies enacting rules that are not required, which is what was raised by Mr. Hendershot, is not at issue. This is a case where an agency required by law to enact a rule did not do it. Remember that 5120.01 is the specific statute requiring ODRC to enact rules when a duty is entrusted to it by law. The parade of horribles isn't going to happen. Many duties of employees can be put into rules, but they're not ones that are entrusted to the agency by law. Agencies have been complying with 11115 for decades without problem. There's no reason why ODRC can't do it here.
Counsel, what's your response to your colleague's argument on standing?
Well, Your Honor, to me, the fact that the statute says that you can seek a declaratory judgment and it can't be objected to because you're seeking a declaration of law, it answers the question by itself. But in terms of there's a controversy and it's real. And O'Neill and Jackson can't wait until they try the protocol out on them to see whether or not it's okay, because they won't be alive to challenge it. And finally, the fact that they're standing, there actually is redress in getting that declaration of law. And I think the General Assembly recognized that when it adopted the Declaratory Judgment Act. So with regard to this case, it's a rule. 01-11 is a rule. It doesn't assign existing duties. It defines first what those duties are, because they said they found 2949.22 vague and in need of interpretation. They could not apply that statute without a rule because they didn't know what it meant until they put their own interpretation to it. So it's a rule because it is defining statutes, the meaning of statutes. It's enacted under the law, giving that job of carrying out executions to the ODRC, and it clearly has uniform and general application. This court has said strict compliance with the protocol is required in State versus Broom. If strict compliance is required, and remember, we're talking about what was entrusted under 294922. All those other things that they're talking about, giving a pillow, escorts, the many things that Mr. Hendershot listed are not part of 294922. What has to be enacted by rule is how the actual execution by injection applied to the inmate of a drug or combination of drugs that will result in a quick and painless death is carried out. That's the core, that's where the rule has to be. The fact is that the protocol includes in it some, under Roman numeral 5, I believe it is, some requirements that are not variable. There's no question that portions of this protocol are in fact uniform and applied generally because they can't be varied. So every inmate that's subjected to it is going to be subjected at the bare minimum to those unvariable components of the rule. So we don't.
Thank you, counsel.
Thank you, Your Honors.
We will take the matter under advisement and you'll be notified of our decision. Thank you.
Thank you. Do I get to sit down yet?
All right, our next case is 20-978, the State of Ohio versus James R. West. For the appellant, Mr. Landusky.
Thank you. Good morning, Chief Justice O'Connor, and may it please the court. Joe Landusky on behalf of appellant James West. I request respectfully that I be given 3 minutes of time for rebuttal. Our system of justice in this great country provides each of us the right to a trial by jury. Should you be accused of a crime in this great country, you have a right for a jury to determine facts in a case. We're all guaranteed this by our Constitution, the right to due process before we can be branded a criminal in our system and lose our liberty. We have that very sacred right, which differentiates us from probably most countries in the world. The most important figure in the administration of justice in a criminal trial is obviously the judge. It is well established that his or her role as a neutral and detached observer is an absolutely essential requirement for administration of justice. Of all the participants in a jury trial, the judge is clearly and by far the most important individual figure. She is looked upon for.
Let's focus at Rule 614. Was there any objections to any of these questions?
At the trial level, sir?
Yes.
I believe there were not objections at times, and sometimes I think that a trial lawyer would feel perhaps that it was fruitless to make an objection to the judge. And I understand your question, Your Honor. I think when it comes to structural error, it may or may not have mattered. I do understand also that counsel could have waited for a break.
Okay, I'm sorry. Let's talk about Rule 614C. Can't the attorney make an objection to the next opportunity outside the presence of the jury?
Yes, sir. I was getting to that. And again, I don't know what role that would have played in this case. I think it might have been a proper thing to do at the time. Again, the question of whether that was done or not, I don't think goes to the issue of what we're claiming to be structural error.
Counsel,
if you don't object and there is structural error, can't the defense lawyer or any lawyer just hide in the weeds and not bring it to the court's attention? Isn't that what you want?
No, sir. I mean, I guess you could say that, but I don't believe there was any intent to do that in this case. I understand there was not an ineffective issue raised. I get that. But what we have, Your Honor, is what was on the record at the time. We have a judge that was very much antagonistic, we would suggest, toward the defense, toward the defendant. And again, while in a perfect world that probably should have been done, I don't know what effect that would have had either way.
Counsel, you establish a record. You're trying the case or you're proceeding below, and there's many objectives there. Obviously, it's representing your client to the very best of your ability, mindful of the fact that what is happening in the courtroom might not be the be all and end all, that there are opportunities upon reflection and review of what happened for the appellate process. And, you know, we all know, and it's been said repeatedly, if you don't establish a record and you don't protect your client with objections when appropriate, you know, you're really tying the hands on appeal.
I understand that, and I respect your point of view, Your Honor, but I would suggest respectfully that whether or not an objection had been made on a break or not, it can unring the bell of a judge who calls a defendant a liar. I mean, there wasn't.
Counsel, let me ask you that. Isn't just focusing on the lack of an objection kind of denying the realities of what defense lawyers have to do when you're dealing with a judge that, in this case, appears to have gone out of his role of the neutral and started cross-examining a defendant before the prosecutor did? Just like when you're dealing with a trial court judge and they exhibit some form of bias, every defense lawyer has a right to file an affidavit of disqualification. And a lot of them don't do that because it just isn't practical to do that in front of the judge that you practice in front of. Isn't that correct?
I believe that to be true, sir. And of course, you run the risk of kind of getting on the wrong side of the judge. They're very powerful. I mean, I would ask respectfully for this honorable court to think for a moment. We always are told to think like a lawyer. I ask you to think as a juror. What is the juror thinking when a person in a black robe sitting above everybody starts questioning the credibility of a witness in a jury trial and undermining their defense?
Counsel, what's a jury to think if the judge is acting in this way and there's no objection to it? So in their minds, it's okay because a lawyer did not stand up after the first question of, you lied to the police, didn't you? Objection, Your Honor. And, you know, it couldn't have gotten any worse by objecting. It's not like you would have, you know, it may have stopped it. You don't know, but there was no effort here.
I respectfully agree with you. If it would have been, for instance, a different situation and a different representation, I think an objection was appropriate. There's no question about it. But here we sit with an individual who's been convicted of a criminal offense, sentenced to a significant period of time in prison, and he doesn't know the process. The jurors don't know the process. All they know is what they've heard from this judge. So the question becomes then, was it a structural type of error? We would suggest it was. It got to the point where
Counsel, okay, say even if it's a structural error, plain error review still applies, right?
I'm sorry, I didn't understand the question, sir.
You keep saying structural error, but even if it's a structural error, we still have to apply plain error review, right?
I don't believe that's necessarily true. I understand the plain error ideas. A jury for it.
Okay, help me understand why you don't think that's necessarily true. We have the United States Supreme Court and Puckett and United States v. Cotton both saying that that is true, that for an unobjected to structural error, you still have to apply plain error review. So should we not follow those cases? Do you think that they're wrong? I mean, what's...
No, sir. The only part about the plain error question is whether in the end there's an outcome determination argument, which I think structural error, if shown, that third prong is not an applicable thing to that. Although even if we go...
That's not what the Supreme Court has said, though, right? You have to show if an unobjected to structural error still requires plain error review. So if we do plain error in this case, how is there plain error? It seems to me that the issue was self-defense, and if we look at your client's own testimony on the stand, it disproves that theory, right? I mean,
I believe that's a way of looking at it, Your Honor. I would certainly suggest that if the judge in this case was so involved with the cross-examination and the teaming up with the prosecutor, the question is whether my client got his due process right to a fair trial, and we would suggest, even with the plain error analysis, that he did not.
Well, Counselor, would that have been, wasn't some of the more damaging, if not the initial damaging testimony, elicited from the trial court judge's questioning?
I'm having a problem respectfully hearing you, ma'am, and I apologize.
No, that's all right. Is this better? Can you hear me better?
A little better now, yes, ma'am.
Wasn't the information that was the testimony that came from defendant that was most incriminating actually responses to the judge's cross-examination of him while he was on direct exam?
I certainly think that played a role in jury's decision when they deliberated, Your Honor, yes.
And then the question of you being asked whether the error was preserved because there were no objections. Hypothetically, let's say there was an objection that the trial court would then have to rule on regarding him or herself. And let's say the court said, as the court did toward the end with curative instructions, you're right, I sustained that objection. I overstepped. I shouldn't have asked these things, which is kind of akin to the curative at the end. Then is there a problem here?
Well, I think respectfully, when the judge had his final instruction to the jurors, it had the same effect when he said, I may get aggravated, but it doesn't matter in effect how you believe I believe. But that, again, I think made it worse, frankly. A lawyer's put in a tough position in a trial, whether to object or not, it could make it worse. I don't think preserving the issue is really germane to what happened to Mr. West in this case. I think what happened was this honorable court, trying to do the best job it could, end up teaming up with the prosecutor, and the jury looks at this judge who is paid to do what he does or she does, and is the real professional in the room, and they're certainly easily going to adopt his point of view, regardless of whether there was an objection or not. I don't think jurors...
Counsel, let's look at the other evidence. Take the judge's questioning out of the analysis here. The other evidence that was presented against your client, my understanding is there was a video, correct?
Yes, yes, ma'am, there was.
And that video showed him shooting, did it not?
Into the ground, yes, I believe. Yes, ma'am.
Okay, he was the only one with a gun, correct?
I don't believe that's true. I believe there was evidence that there was another gun there that was seen or talked about during the evidence.
Is there a link between the gun your client had and the bullets that ended up in the leg of the victim?
I believe that it could be established that yes, that would be true. And the question is whether that the use of deadly force was reasonable under the situation, considering self-defense, which was his complete defense.
Okay, so the jury had apparently the video, the whole scenario to look at, to see what the interaction was between the victim and your client.
Yes, ma'am.
Would you say that video was supportive of self-defense or not?
It depends on how it's looked at. And I think that's a great question, Your Honor. One of the things that the court also said was you were questioned by the police, you lied to the police, and a complete statement was made by the court about how he didn't claim self-defense at that time. And there were words also about when someone said the N-word, I'm going to take your shit, excuse me. the judge interjected and said, he didn't say he was going to rob you. So it kind of it took away from his defense. I believe my time is now come up. I've only got 2 minutes left, but I want to thank you for the opportunity.
May I ask one question? May I ask one question? If this is structural error, does it really matter whether the state had a decent case or not? Does that matter?
I would certainly suggest not, sir. Thank you.
Right, Mr. Walton.
Thank you. Good morning, Chief Justice, and may it please the court, your honors. Finding that the plain error analysis does not apply in this circumstance would create a perverse incentive. It would encourage a defendant to refrain from objecting to what he believes to be fundamental serious error. As I pointed out in the state's brief, the precedent from this court, the precedent from the Supreme Court of the United States, and judicial economy each require the opposite. So therefore, the state's asking that this court affirm the 10th district majority in this case. Litigants must be required to seek a fair trial the first time around, instead of sitting on their hands in the hope of gaining a tactical advantage later on down the line. And because of this, even claims of structural errors must be preserved for direct appellate review in order to entitle a defendant to automatic reversal.
Counsel, how did the curative instruction occur in this case? Why did the judge even reference that if he didn't feel that he stepped over the line?
The curative instruction came at the end of the case, and it is the first part of that is the standard instruction given in most cases that I have seen. That is the almost straight out of OJI, saying if the court did anything to indicate to you what you believe the court's opinion, ignore it. Now, Judge Sarrett here did go above and beyond that and add a little bit more to that, but this was the final instructions that the jury received before deliberating.
But he went more beyond the general instruction of don't take any impression that.
Justice Donnelly, you're muted.
All right. He specifically referenced his questioning.
He said sometimes I can get aggravated, and he also said if I did anything. So I don't think it's fair to ultimately link this to him and his belief that he had crossed the line. I think it's a bit of a stretch to say that.
You don't believe he crossed the line when he called the witness a liar?
He did not directly call the witness a liar. What he did was he was attempting to short circuit the cross-examination. The prosecutor's question was designed to elicit a negative response from the defendant, and there were going to be 2 or 3 more follow-up questions to that. The trial court was jumping to the conclusion and simply trying to bring it all to a swift conclusion. And so in other words, he's trying the case for the prosecutor. He was asking a question, trying to keep everything running on time. Now listen.
Wait a minute. Running on time. What else did he have to do except hear this case? I mean, that's the job of a judge.
Chief Justice, I don't disagree with you. And if you were to ask me, would I prefer that he had simply stayed out of it and let the prosecutor do his job? Absolutely, I would agree with you.
Why didn't you object?
I was not the prosecutor that tried it.
Why didn't the prosecutor object?
Well, that's the question. Why didn't the defense attorney object? Why didn't the prosecutor object? Because, I'm analogizing this a little bit to manifest weight of the evidence review. When a case is on review, the reviewing court is going to defer to the individuals who were in the courtroom at the time, and they were able to observe what was going on. Now, in a manifest weight situation, we're talking about what the jurors saw, the tone of the witness, inflection, any gestures that went along with it. Here, we're stuck with the same situation. We're reading words on a page. The individuals who were in that courtroom, the 2 attorneys, both decided that this was not objectionable. But certainly,
no, counsel. I think that's not the correct conclusion. That 2 attorneys, the state and the defense, said, "Have at it, Judge. You're doing a great job, and we're not going to object because this is appropriate." I just heard.
I'm sorry, Chief. And the analogy with the jury is just not a good one either. The jury can't participate verbally in the middle of a trial. They assess things, as you say, for manifest weight if it's a jury trial, but they can't stop and start asking questions themselves from the jury box.
Correct. What my analogy, what I'm saying is, when we're looking at why these 2 attorneys didn't object, they were both in the room. They were both observing what was going on. So
and that means they would have both had to do something that's contrary to the one person in the room who rules the roost, the judge.
Well, ultimately, the burden of establishing plain error is on the appealing party. And certainly an objection could have been raised, and I think should have been raised. That's part of the issue here, is that the objection was not raised. The contemporaneous objection requirement is extremely important in our legal system.
So had an objection been raised here, would you find structural error and automatic reversal?
Well, if an objection had been raised, there's 4 reasons that the objection is important. Number one, it prevents a defendant from gaming the system, as I referenced in my opening. Also, raising the objection allows a trial court to adjudicate the claim and create a factual record that facilitates the appellate review. Some errors can be corrected immediately through curative instructions. That's the third. And finally, if an error can't be cured, if it's so serious, the trial court can grant an immediate remedy, like a mistrial, and that would get rid of the need to file an appeal and have the delay associated with an appeal be a part of it. And so it would get this back in retrial sooner.
You're not saying that we can never notice structural error without an objection, are you?
I am saying there are 2 modes of review on appeal. There are 2 kind of conveyor belts.
I
There's
need
a harmless.
Yes or no. I'm not talking about plain error. I'm talking about structural error, because if you have a judge who's not impartial, you do not have a fair trial. It's a given. So if can we notice structural error without an objection?
Not unless it consists of plain error. And you have
I'm
to be
not
able to
talking
show.
about plain error. I'm talking about structural error. If you look at the Baston case, in the absence of any showing of any bias, prejudice, or prodding of a witness to elicit partisan testimony, it will be presumed that the trial court acted with impartiality. So what we're saying is this: what's being said in this case and alleged is this is an impartial judge. And when the judge was impartial, the defendant could not get a fair trial, period. And when you look at the testimony where he actually cut off Mr. West, and he said, in order to give yourself a fighting chance, you felt that you needed to lie to the cops. And West said, right, because if I pled guilty that day and the judge said, your answer was right, thank you. Is that prodding a witness, and is that an impartial judge?
That was the prosecutor with those questions. That was Mr. Pearson who cut him off right there. That was at the very tail end of the state's cross-examination. But to get back to your original question, my answer is unless you can meet the plain error standard, because there is no standard of review known as structural error. There are errors that are very serious that constitute what the U.S. Supreme Court has called structural errors. It is a limited set, but it does exist. But there is no standard of review known as structural error. So you don't simply just get to say, I have a biased trial judge and have a court presume that the trial court was biased and automatically reverse the case.
But a biased trial judge has been, I just read you out of Baston, which is a major case, and bias, prejudice, prodding a witness to elicit partisan testimony. We can't look at the questions that the trial court asked and determine for ourselves whether or not this defendant was getting a fair trial based on an impartial judge. We're not able to do that.
Well, again, you have to decide what standard of review you're in. And if there's an objection, and that's what the U.S. Supreme Court has said over and over, this court has said it at least twice, that you have to object and preserve the error for review. Otherwise, you're stuck with the plain error standard, because otherwise you're going to create the incentive not to object when the error could actually be corrected. And in this case, the defendant, of course, failed to lodge any objection. And as this court has held, that means you get locked into the plain error standard of review. And because we're in that standard, you either have to show clear.
What if the judge is so bad that if, and I'm bleeding this a little bit over into ineffective assistance, but what if the judge is so bad that the concern is that if you say anything, it's only going to make it worse?
I would say counsel has a duty to raise an objection to what they believe to be objectionable behavior. Now, you can't make an omelet without breaking some eggs. And of course, if you're gonna sit on your hands and you're not going to raise this objection, the defendant's going to be stuck having to establish plain error on appeal.
Counsel, let me ask you a hypothetical. Let's assume that the judge didn't ask any of the questions that he did in this case. And right before instructions, he said, you're about to go back and make your decision. Oh, but as an aside, I believe the state proved its case, but don't take that in my opinion. Would that be structural error?
Assuming there's an objection to that, and defense counsel should be jumping out of their chair at something like that, yes, I think that would be a problem. That would be a problem because the judge would. Sorry, go ahead.
That would require an objection, though, to preserve it.
It would require an objection to preserve it, and then you would be stuck showing either clear outcome determination or reasonable probability of a different outcome, depending on which standard of plain error this court's going to apply.
And it's okay for the prosecutor, who's also an officer of the court, to just sit on their hands when it's that egregious?
Again, I think that the fact that there wasn't an objection from either side cuts against the fact that this was so egregious. Now, if you're talking about bias, it should be jumping off the page and it should be smacking you in the face. It should not be this, we're going to interpret what the judge said here. And well, he said this here and adding all of these things together. In Toomey versus Ohio, the open bias of the court was obvious. It was open for everybody to see because the municipal ordinance at issue clearly said the compensation of the mayor was tied to him finding defendants guilty. So that is something that is open and obvious. And if you're going to reverse in a situation, it needs to be open and obvious and not subject to interpretation as it is being raised by the defendant in this case.
Counsel, is this standard operating procedure for this judge?
I can't say. I don't have a large sample size, but I know that he takes a more active role in the process. I think even in this transcript, he mentions the fact that he was, he was a trial judge, a litigant for a long time. He was defense counsel. So, some judges take a more active role than others. Some sit back more than others. So, occasionally you're going to get more involvement from one judge or another. So it's just something that happens. And I don't think it's necessarily unique to this particular judge.
Well, if you're comparing the performance of the judges, would he be top of the list as far as what you call euphemistically active, taking an active role?
I would say that's fair. I don't know if he's the absolute top of the list, but I think he's up there, certainly in the top half from my experience at least.
Okay, thank you.
So this court has held that a trial judge is presumed to follow the law and not be biased. So the appearance of bias or prejudice, it must be compelling to overcome those presumptions. In other words, the alleged bias has to be right there and not subject to interpretation. And the biggest problem for the defendant in this case is that the two questions that were asked by the trial court were essentially statements of undisputed fact. The defendant was caught on surveillance video shooting at the victims in this case. And second, the defendant did lie to investigating law enforcement officers. Simply because he asked those particular questions, it didn't reasonably indicate to the jury the judge's opinion of the defendant's credibility or the weight to be given to his testimony. It was clarifying two issues of fact.
Mr. Walt,
you don't think he made a statement as to the defendant's credibility?
He said you lied to the police, didn't you? Which is a statement of fact. The defendant in this case, there is no dispute. He did lie to the police. Now, if the judge had instead said, you lied to the police, why should we believe you now? That would be a big problem. That would reasonably indicate to the jury the weight to be given to that particular testimony or the credibility of that defendant.
Mr. Walton, let me ask you a question. As
Yes,
a prosecutor, wouldn't you value a rule coming from this court that told trial court judges throughout the state that during jury trials, substantive questions of cross-examination of either side is off limits and let the lawyers do their jobs and we could have more uniformity? Do you agree that the system would benefit from that?
I don't know that you necessarily need to go that far because I think there might be some situations where it could be helpful. Is this one of those cases? No, I don't think this is one of those cases. but I think you could probably imagine a scenario where a judge feels, with their duty to protect the record and to facilitate ascertainment of the truth under Evidence Rule 611. I don't think you want to create a bright line rule saying absolutely no questions.
Well, but
No,
at all.
if you can proffer evidence, why can't a judge put that on the record outside of the hearing of the jury?
I'm sorry, if you can do
If
what,
you
Your
can
Honor?
proffer evidence, why can't a judge put that on the record outside of the hearing of a jury?
Put the evidence on the record outside
No,
the hearing of the jury?
I'm analogizing. If you can proffer evidence, why does a judge have to do cross-examination of someone on the record, especially in front of a jury? Why can't the judge put that on the record outside of the hearing of a jury?
I suppose the judge could do that, but if we're talking about a bright line and categorically forbidding a trial court from asking any questions on cross, I don't think we need to go that far, particularly in light of Evidence Rule 611. So unless there are any further questions from the court, for these reasons, I request you affirm. Thank you.
Thank you, Mr. Walton. Mr. Lundusky, I think you've got about 2 minutes left. So proceed.
Thank you very much, Your Honor. The state, we would suggest, is trying to put a new rule in there that unless there's an objection, there can't be structural error. One of the things the prosecution of the state has just stated is that this needs to jump off the page.
Just to be fair, no one's arguing there can't be structural error without an objection. What I think Counselor's saying, which is simply the law, is that you have structural error, and how you evaluate that structural error depends on whether or not there's an objection, right? If there's an objection.
Yes, sir. And that leads to my final point and my final statement with regard to structural error in this particular matter. Mr. West tried to explain by questions from the prosecution and cross-examination why he didn't say certain things to police, to which the judge, and I quote, said, "It wasn't a question of pleading. You waived your right and you made a statement to police. You didn't tell them it was self-defense at the time. It's just that simple." Those are the words from the judge. That jumps off the page, I would suggest. And then he finally says, "Right?" As if it's a question. It was respectfully the judge testifying and telling this jury at the time that you didn't say anything about self-defense before now. The state just mentioned if he would have followed up with, isn't it, you're lying then and you're lying now. That's what is to be inferred by that question. Anybody with any kind of common sense would be able to say, that's what the judge is saying. You're a liar then, you're a liar now. My client respectfully did not receive a fair trial. I'm asking you to give him another one. It's not going to hurt the state. It will help justice. Thank you.
Thank you. Thank you, gentlemen. We will take the matter under advisement. You'll be notified of our decision. Marshall, will you call a 15-minute recess, please?
Thank
The court
you.
will now adjourn for a 15-minute recess.
Thank you.
ladies and gentlemen. We are here on our final case this morning, 2020-1078, State ex rel Ohio Attorney General versus Robert Burns et al. For the appellant, we have Mr. Kearney.
Good morning, Madam Chief Justice, and may it please the court, I'd like to reserve 3 minutes for rebuttal. Your Honors, Robert Burns is strictly liable for the public money lost by the charter school he ran for 3 reasons. First, the statute holds public officials liable if they collected or received public funds. So whatever collect means, it means something different from received. Second, standard definitions of collect include what Burns did here, which was to obtain money for his charter school, even if he had the money sent to a treasurer. And third, liability here is consistent with the common law of over 170 years, which has long held officials liable to protect the public, even when the official is not at fault. And if any of that seems...
Counsel, what was Mr. Burns' role?
So he was the CEO of the charter school. And so in that capacity, he was registered as the authorized representative to get online and apply to the Ohio Department of Education for funds. So he's the one who sat down and said, please send my school this money. He also submitted expenditure reports showing that they had spent the money so that the funds could keep flowing. And the Jones affidavit, paragraphs 2 to 7 says, and Burns never disputes, they could not have gotten this money if he didn't do his part. It's just that when he said, send this money to my school, he said, drop it in our account. And that account was then controlled by a treasurer who is a separate person. And the treasurer reports directly to the board.
And counsel, who misused the money? Who actually misused the money?
Well, the treasurer here was definitely the bad guy. He pleaded guilty in federal court to embezzlement, no doubt about that. But what this court's cases have always said is even when there's a worse actor around, for example, in Harper, the money was stolen from a treasurer's house. And this court said, you're still on the hook. In Seward, the money was in a bank and the bank failed. And this court said, you're still on the hook. And so this court has always said, strict means strict. And if
Counselor, in all the cases that you're talking about, name one case where the public official has been held liable, responsible, who had no control over the funds.
Well, I'm glad you asked that, Your Honor, because we readily concede there's no case directly on point where liability has been imposed.
So we're talking about over 175, 200 years.
On the other hand, Your Honor, it's equally true and just as important that they cannot cite a single case, and we could find none, where someone was let off the hook for lack of control. And the problem with control
Mr. Kearney, you cite the common law rule. So let's go back to the common law. Can you find other cases where someone who had no control over money was held liable under the common law rule?
No, they've never been held liable or not liable because it's rare, as far as I can tell, for someone to set something up where they apply for money and don't turn around and receive it. So
that's not true. I mean, under your theory, I mean, you know, say you're at a state university, there's all kinds of people who are responsible for filling out forms, asking for different kinds of aid. They may have no responsibility at all for the actual administration of that, but I would be hard pressed to think that we were going to hold some innocent bureaucrat liable just because someone else stole money through no fault of their own, and they had over which they had no supervisory powers.
Well, there are a couple of answers to that, Your Honor. First, I want to stress the importance of the word or, because this court said in Columbia Gas Transmission that when the legislature uses or in the disjunctive, it means both halves mean something. And it's not as if we and our friends on the other side have competing definitions of collect where they say, oh, collect means this, not that. No, they openly say, yeah, we're importing collect and receive together and collapsing it in. And they talk about interpreting the phrase, they say at page 12 of their brief. They never offer a standalone word definition of collect. And that's wrong.
I guess my question was more about the breadth of the rule that you suggest. I mean, this would make any person at any public institution, any government agency who signed any form asking for someone to pay money to that agency liable despite their having no culpability at all in the funds being misspent? Am I
Well, Your
missing
Honor,
something there?
there are a couple answers to that. First, I understand that does sound broad, but we think that's not going to be a frequent problem. I'll tell you why. And if so, it's for the assembly to fix. First, it's not likely to be a problem because, for example, in this program, the Department of Education doesn't just let a school janitor or the first grade teacher hop online and apply and we say, sure, here's money. The funds are set up so that only someone like a treasurer or CEO is set up to be an authorized representative to seek funds. And so it's not only from the state end of supplying the funding, but also
but that's not always the case, right? I mean, there you can certainly imagine situations where all kinds of people are allowed to submit invoices to someone and have no managerial responsibility at all.
Well, and that is why if the legislature thinks that is too strict, they could go in. For example, my friends on the other side point to the special statute about treasurers at regular traditional public schools that specifically gives circumstances where strict liability is softened. That shows the legislature knows how to do it. And again, the problem is any of these readings that turn on.
Counsel, didn't Mr. Burns, his duties included the general supervision and the management authority of the school? This is and personnel. I mean, he was more hands-on than the university president or the grant writer or any of the other examples here. And he also had the authority to approve budget expenditures on behalf of the school. And he was active with the electronic accounting system that was set up through the Department of Education, was he not?
That is all true. And what it shows is to the extent that there was any hole in that system where the treasurer could waste money or misappropriate or embezzle that he didn't see, the strict liability creates an incentive for a public official such as Mr. Burns to say, hey, I know I might be held liable, so let me set up systems like dual signature authority, like a lot of
But none of the things that Chief Justice mentioned are applicable to your legal theory, are they? I mean, your legal theory is based just on the fact that there was a signature on a form. It doesn't matter whether it would apply equally to someone who had no supervisory responsibility over those funds.
Well, that's true, Your Honor, in that it turns on the word collect. And again, that's the legislature's choice. If we make receipt a prerequisite, then we're openly saying that you could just cross out the word collect and have the statute say received and nothing would change. And we're told by the legislature in 1.49, and we're told by this court in Columbia Gas Transmission, we shouldn't do that. I am struggling to come up with...
We've got so many different interpretations of the word collect. I guess going back to what Mr. Burns could have done. I mean, so he has no supervisory responsibilities over Mr. Shy. He didn't hire him. His contract was not with him. He didn't control the funds. What is it that he could have required what could he have done to better protect the funds? So, because yes, he's bringing in the money, he's getting federal and state monies. Arguably, if he didn't do so, he would be derelict in his duties to the school. So what is it that could have been done that should make him liable for the theft of these funds?
I'm happy to address that and also back up and talk about your part of the question about the definition of collect. Okay. First, what he could have done is he could have said, hey, I'm only going to take this job if I have secondary check writing authority so that you need 2 signatures and this guy can't send money out without me.
And do you have an example of any public official who's done that?
I don't have anything in this record, but I'm aware that the auditor recommends to local governments dual check signature authority routinely to places when a local clerk, village clerk or treasurer runs off with money. The first thing the auditor says is, why don't you require 2 signatures before public money goes out the door? But the other thing about those incentives is if he knows, like any CEO, that the best laid plans of mice and men or CEOs and treasurers might go awry, let's set up controls about that. Is the alternative is, instead of putting the liability on him, is to leave the public holding the bag. And that's
Well,
why
it's
there's a
it's
canon.
interesting, Counselor, you said that because the auditor, the state auditor in 2014, in a bulletin said that public officials also should be aware that they could be personally liable for illegal expenditures of public money under Ohio law. Any public official who either authorizes an illegal expenditure of public funds or supervises the accounts of the public office from which such illegal expenditure is made is strictly liable, and goes on to say public officials controlling public funds or property are liable for the loss. So again, that's the auditor, who of course is now the attorney general.
The important thing about all of that language, just like some of the case law that uses the word control, is it never says you're liable only if you control. It's true, if you control money, which comes from receive, you can't control it if you haven't received it. If you receive money, you'll be held liable. It's also true that if you collect money, you'll be held liable. So
Where
this
is that?
reminding people about one of the prongs, which
But
we do.
where is that? That's not in this bulletin. That's not in any case law that you've cited.
It's in
You
the
talked
statute.
about 200
And that's
years
the
of
key.
this.
The word collect. For example, if you look at 9.38, the companion statute about depository duties,
Mhm.
that one uses the word receive or receipt 9 times, never uses the word collect. So the legislature, and it used to, and my friend on the other side points to that statute as the origin of this phrase, collect or receive. So the legislature knows.
Counselor, but if I say that you ate or consumed your meal pretty quickly, do those two verbs have different meanings for you?
Well, Your Honor, there are verbs where sometimes there are two parallel words. But here, we recognize there are lots of times you can receive something where you never applied for it. Things are on autopilot, things just get sent to you. So received and collect are not like give and bequeath where they're just two
Well,
parallel
now you're
surpluses.
swapping out the word applied for collect.
Well, Your Honor, collect, the first fundamental principle we should, I hope, all agree on is whatever collect means, even if I'm wrong, collect has to mean something that doesn't zero it out to nothingness. And that means receipt can't be, whatever the formula is for collect, it can't require actual receipt. And so that's where control, which is a word not in the statute, doesn't apply. And think about common usage. If someone posts something online that says, I'm collecting for charity, here's the link. And the money might go directly to that charity and to their bank account, but we still say, I'm collecting for charity. That's a common usage. And as between competing dictionary definitions, we have to favor the one that gives meaning to every word.
I mean, it isn't really what, I mean, to me, I mean, the definitions certainly overlap, but to me, there's simply, they cover kind of two senses of the same thing, right? You receive something there's nothing proactive about that. Collecting is taking a step to go out and gather things up for you, right?
Right.
And there's no reason we can't think the legislature wanted to make sure that both senses of the words were covered.
Right.
But I don't get the next step that you take to say, well, that has to mean that something can be collected that has not been received by the person. I mean, we, in ordinary English, we use overlapping senses of a word all the time, right? One's more specific, but when you collect something, you also receive it. But that doesn't necessarily mean that the legislature meant to draw this big distinction there, does it?
Well, Your Honor, sure, they overlap. No one doubts there are factual situations where you've both collected and received, and in life too, that collect and receive can overlap. The difference is there's a difference between saying overlap and saying collect is merely a subset of received and has no independent life of its own. And that's the rule this court said in Columbia Gas, and more broadly in the give effect to every term, is if we adopt the reading where collect includes receipt, then we are admitting that you could just blue pencil it out of the statute and life would go on with no change. And this court said we don't do that. The legislature tells us not to do that. And also, if there's softening to do, the legislature can do that. They've done that for public school treasurers. They could do that for charter school CEOs if they want it. They haven't. The rule is you keep it strict, let the legislature soften it. And in addition, think back to all of these cases where someone was robbed at their house, or a treasurer put money in a bank and the bank failed. Those are totally sympathetic situations. No one doubts that. And this court said, well, we're putting the strict in strict liability. And if it seems too harsh, we leave it to the legislature.
The Attorney General has various people that work for it that collect money, right? They collect money that's owed to the state. Now, if they collect that money and someone in the state, and these are simply people who just are collection attorneys, right?
I'm on the hook too.
So that person is going to be on the hook if down the road someone else in the Attorney General's office misspends that money.
I see I'm out of time, but if I can quickly answer that. Yes, and that's why we have things in place, office policies,
I'm sorry,
so that losses are repaid so it doesn't roll down to me.
Hold on, I'm sorry. Did you say yes to Justice DeWine's question?
Yes, and it does seem awfully strict. And I admit look, I'm putting myself arguably in jeopardy by doing that because I work on all sorts of cases. But I also know we have institutions in place so that that money is protected step to step, so that that's not going to happen. And we don't have a spate of cases going after every low-level employee. But if there is some reason to distinguish high level from low level, certainly Burns meets that here. And that's why, although we don't think control is required, the trial court and the dissent both said he exerted a form of control when he told the agency, please send the money to this account. He directed it to where it was to go.
One final question, because I know you're running out of time. Does it matter whether the misappropriated funds have been recouped from the perpetrator?
Oh, sure. And we have collected some. That's why the amount we're requesting is only down to, I think, 60,000 from what was originally, he helped obtain over $400,000. I forget the exact amount of misappropriation found in the finding, but we don't double collect. If someone else steps up first, and that's why all these other people are usually not on the hook, but the gentleman who stole the money and went to prison might not be collectible from beyond a certain point. And I think, I don't want to get this wrong, so I defer to my friend on the other side. I think there might have been something in the record about an insurance policy that might or might not be in play. But in any case, we just want to impose the liability on him because it's him or the general public. And this court should hold the public protected and put the incentive on someone who at least can do something about it. And so we ask the court to reverse and reinstate the trial court's finding of summary judgment in our favor.
Thank you. Ms. Cooper.
Thank you, Your Honor. Chief Justice O'Connor, and may it please the court. My name is Janet Cooper, and I represent the appellee Robert Burns, who during 2009 and 2010 was the director of New City Community School here in Dayton. This case involves the circumstances under which a public official can be held personally liable for the loss of public funds. Ohio law applicable to this case preceded Ohio's statehood. It's consistent throughout the United States. Succinctly and consistently stated by this court over multiple decisions is the rule that public officials are personally liable for the loss of public funds they control. The common law was codified in Ohio in 1985 with the enactment of Revised Code 9.39, and the first sentence reads, all public officials are liable for all public money received or collected by them or their subordinates under color of office.
So if what that really means is control, why wouldn't that language just be in the statute?
Because this statute was codifying the common law, and the common law was clear that control of funds was a requirement.
So if the common law was control of funds, why not? And this was codifying the common law. Wouldn't the statute say control of funds?
Well, I think for years, the phrase received or collected had been used in Ohio statutory lexicon with respect to the fiscal management of the state to mean possession and control of funds. For hundreds of years, in cases that literally span 3 centuries, this court has consistently held that public money in the hands of or under the control of a public official constitutes a trust fund for which the official as trustee should be held responsible to the same degree as the trustee of a private trust fund. This court reaffirmed this principle in its 2010 decision in Cordray versus International Preparatory School by stating that it is firmly entrenched in Ohio law that public officials are liable for the public funds they control. Now, in Cordray, the issue before the court was whether an employee of a community school is a public official within the meaning of 9.39. The court answered this in the affirmative and then said, but there's a factual issue that needs to be determined. And that is whether this particular public official was personally liable for the loss of public funds and whether he received or collected them under color of office within the meaning of Revised Code 9.39. So the dispute in Cordray there was uncertainty about whether that public official was actually employed as the treasurer of the community school. And this court said, giving guidance to the lower court when issuing the remand, that the label placed on the position is not what controls the outcome. What matters are the duties of the position. And then the court said what the duties were that result in personal liability. And I quote, it's the public official's obligation to account for and disperse according to law monies that have come into his or her hands by virtue of being such public officer. Now, the issue in this case is identical to the issue in the Cordray case on remand, and applying this court's guidance to the undisputed facts of this case compels the conclusion that Robert Burns is not subject to personal liability for the loss of public funds belonging to New City School, because no public monies ever came into his hands by virtue of his employment, and having no control, he had no obligation nor indeed ability to account for and disperse these funds.
Counsel, did he direct where that money was going to be deposited once the state said, you're getting this money? Because he applied for it. And I would imagine on the application, there is some indication of where that money should be transferred to, should the application be approved.
The funding scheme, no, is the short answer to the question. The funding scheme was set up by the Ohio Department of Education. Grant funds are applied for, budgets are drafted, and then once the budget is approved, there are 2 clicks of a computer mouse that are required on the department's website to approve those expenditures and release the funds directly to the bank accounts.
All right, who does that? Who does that 2 clicks?
One was Robert Burns for New City School, and the other was Carl Schy, the treasurer.
So, okay, they both clicked?
It required 2 authorizations, yes. But
okay.
That was an ODE system. It was not set up by Robert Burns.
Yeah, I understand that. To me, that sounds like he was integral to securing those funds and directing where they got deposited, because that's what Ohio required.
That's what
right?
Ohio required, correct.
All right, so he collected those funds and he saw to it that the bank account of the organization that he was he CEO? Was that his role here?
Director was his title.
All right, but he saw to it that that money went to the bank account of the institution that he was a director for.
Well, that was all set up in the system. He didn't set that up. He didn't open a bank account. He didn't say, pay the funds here.
Oh, that's irrelevant.
Okay.
But he's the one that had to facilitate the transfer of the money from the state to the coffers of his charter school.
He approved release of the funds, a responsibility he shared with Carl Schy.
Okay, but it doesn't say he had to have sole responsibility in the statute, does it?
No, but I don't believe that that click of that mouse constituted collection within the meaning of 9.39.
Where's collection defined?
It is not defined, except as if the common law existed at the time that it was codified.
Okay.
If he participated in the budgeting process, isn't he designating how those funds are being spent?
Supposed to be spent, yes.
Does that count?
Well, he wasn't responsible for misspending those funds, nor did he have any control over them being misspent. He approved the lawful expenditure of public funds, but he did not then carry those orders out because he had no authority to do that.
Thank you.
Now, New City's Board of Trustees is the one that gave control over all fiscal matters of the school, including its bank accounts, to Carl Schy. You know, the state says that Robert Burns set it up so the funds would go to New City's bank accounts. He didn't set that up. That was set up by the board and by the treasurer. Mr. Schy was not an employee of New City School. He was an independent contractor appointed by the board to serve as the designated fiscal officer for the school pursuant to Revised Code 3314.011. At no time did he report to Mr. Burns. He always reported directly to the board. His physical office was not located at the New City School. Instead, he performed his work on behalf of New City as well as a number of other Ohio community schools from his home in Columbus, Ohio.
Counsel, how long did it take before $400,000 was determined to be missing by the audit?
There was not an audit that said $400,000 was lost. It was in the neighborhood of $45,000.
Oh, 45.
Yes. Carl Schy stole upwards of $1 million from Ohio community schools. He was in the process of being sentenced when the audit report in this case was issued for much of that. The $45,000 that was attributed to New City later, after he was sentenced, is what we're talking about in this case.
Okay, all right. But again, my question, he's pilfering money. He's taking money that should have been spent on, for accounts or whatever was in the budget that directed this money had to be spent on. How long did it take him to do this and then be found out?
The audit report was issued May 12th, 2012, 2 years after New City closed. And the actions took place in the 2009-10 fiscal year.
And according to what's here, I thought it was 65,000 and not 45,000.
Well, there have been interest and penalties assigned since that time. I'm kind of lost track about what the exact amount was.
Okay, thank you.
So the attorney.
Are you aware of any reason why the misappropriation of funds would not have been discovered a lot sooner?
Well, he didn't advertise that he was stealing public money.
Sure.
And there isn't anything in the record. I will say there was a lot of chaos associated with Mr. Schy's activities as treasurer of all community schools, which came out later. Ohio was not paid unemployment taxes on time. Workers' comp premiums were not paid on time. Paychecks for employees were not paid on time because he was shifting money between one community school and another to meet whatever needs were critical at that particular time.
And neither Mr. Burns or any of the other directors had any supervisory or control powers or features or any way to hold Mr. Schy accountable?
That's absolutely true. Mr. Burns took his job with specific job duties, and they did not include supervision of Mr. Schy or his activity.
Supervising him. Who was supervising Mr. Schy?
He reported directly to the board with whom he had been appointed by the board as an independent contractor for the school.
And was he giving them false reports?
I don't know the answer to that.
Was he accountable to each board, each school's board? He was he was an independent contractor for everything?
I don't know that is the way it was set up in every community school, but it was certainly set up that way at New City.
At New City, okay, thank you.
So let's talk about the disjunctive or between the terms in the statute and why that means they don't need to have exactly separate and distinct meanings with no overlap. So the Attorney General is saying that Robert Burns collected public money when he triggered the release of public funds to the bank account. And the trial and appellate courts in this case did consult dictionaries to define the two terms, as did the Cuyahoga County Common Pleas Court on remand from the Cordray case. Well, they each consulted different dictionaries, and not surprisingly, they arrived at different conclusions. The Attorney General accuses Mr. Burns of contending that the two terms mean the same thing and of misreading the case law by reading the requirement of control into the phrase collected or received. Well, first and foremost, it was not Mr. Burns who read the requirement of control into the case law. This court used that very word repeatedly in its decisions, most recently in Cordray in summarizing Ohio law, which he characterized as so settled that it hardly needed to be restated. But Mr. Burns is not contending that received and collect are synonymous terms. Collect is an active verb, as Justice DeWine pointed out. It encompasses a variety of potential activities to come into possession of funds, while receive is a passive verb, which requires no action in order to possess funds. Both terms, nonetheless, include the concept of possession and control. It is Mr. Burns's position that there is overlap in these two definitions, and the phrase received or collected embodies the rule of common law that public officials are liable for the loss of public funds they control.
Well, counsel, if you collect something, that doesn't necessarily mean it's going to be under your control. And I think the example was given, I forget what justice gave it, that if you put, for example, a GoFundMe request on, the internet, that money doesn't go to you. There's a bank account that people will send it to, and you're not touching it. You're just, putting out the request for money, and in other words, you're trying to collect money to go into an account that is not your personal bank account.
That's correct. But under what legal theory would the person who sends the GoFundMe request be held liable if those funds that go to that separate account then are squandered in some way or lost? And that's the problem here. I haven't collected the funds. I've assisted in the process of collection, but I haven't collected them because I haven't received them.
Oh, no. Now, so you're saying if you're collecting something, in order to be liable, you also have to receive it?
Within the meaning of 9.39, yes, sir. Yes, ma'am. That is exactly what I'm saying.
Okay. All right. That makes it clearer.
Thank you. There is no indication that the General Assembly intended to alter the requirement of control in enacting 9.39. It is clear in formal opinions issued by the Ohio Attorney General and bulletins issued by the Ohio Auditor of State that these two offices have historically understood 9.39 in exactly the same way that they now claim the appellee is mistaken about. That receive or collect means custody or control for personal liability to attach. And I would call your attention to a 1994 Ohio Attorney General opinion where it is clear the Attorney General called the language of 9.39 plain and unambiguous. And he said public officials are held liable only for public money that they or their subordinates receive or collect. Thus, a public official will be held personally liable if public funds that come into his possession or custody in his official capacity are lost, making it clear that the phrase receive or collect meant possession or custody of public money.
So stopping you right there. So that is the reason then that some public officials need to have a bond, because the bond then covers their personal responsibility for those monies lost, correct?
That's correct. And in Ohio, treasurers and Carl Schei was required to have a bond, but people who work in the capacity that Robert Burns did have never been required to be bonded because they didn't have any custody or control over public funds.
Thank you.
The law governing.
Thank you, Ms. Cooper. You've used your time.
Thank you.
Mr. Carney, let's see what you have left here.
Zero.
I'm shocked. None. Let's give you a minute.
Okay. Thank you, Your Honor. 2 quick points on text and the facts. On the text, I appreciate the acknowledgement from counsel that I believe I heard that said her definition of collect includes receive. And what that means is that collect has no independent meaning. Now, she also referred to whether there's no overlap. Our position is not that there's no overlap. There's lots of overlap. It's just that, like a Venn diagram, there's a lot of overlap, but there's some receipt that does not involve collecting, and there's also some collecting that does not involve receipt, because that's the only way to keep both words alive. And if she can't offer any definition of collect that doesn't just collapse into receipt, then we're admitting we're deleting terms from a statute, and we ought not do that. As far as the facts and that 2 clicks is, yes, ODE required both of them to click to take the money. If they would have done the same thing on their end and required dual signatures or dual turn the nuclear keys to have money go out the door, then we wouldn't be in this situation, because he would have known every time Shai was spending money. And that's what we want to incentivize. Take care of the money the state gives you, spend it on the children, and don't let it go out the back door. And if you don't like your fate being tied to someone who's untrustworthy, don't take a job where you dual click together and then wash your hands and walk away. He should be held strictly liable. And if the General Assembly wants to change that, that's their job, not this court's.
Thank you. Thank you. Thank you both, counsel. We will take the matter under advisement and you will be notified of our decision. Marshall, will you please adjourn court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.